Hey, Legal Eagles. Remember all those crypto and fintech law courses from law school? Probably not, unless you took mine. So it's time for you to reskill, upskill, and lead. Join our Pivot Your Practice Summer Web Training Series so you can go beyond your JD to 10x your value in Web3. Gain essential knowledge and strategies in financial regulation, compliance, IP, and more. With only 20 seats available, don't miss out on over $5,400 in value without wasting time or money on traditional approaches that, quite frankly, haven't caught up to the future client's needs or even present-day realities. Register now at advantageevans.com and go to the head of my class. That's advantageevans.com.
This is JoAnn Holmes, and you're listening to Tech Intersect. Entrepreneurs need to do a balancing act between finding that product market fit where they have confidence that they're going to generate revenue, especially if they're not funded, as well as being aware and being proactive of some of the legal issues and steps that need to be taken early on so that that investment in building up that product market fit is going to pay off for you over the long term. Certainly, intellectual property is a piece of that. And so if we start from just a baseline, what are we saying when we mention intellectual property? So we've got trademarks, which are brands, logos, and slogans. We've got copyrights, which are the way that we protect original creative works. We've got trade secrets, which are competitive business advantages that you maintain as an IP asset by keeping them secret. And you've got patents, which, to simplify it, is the way that we protect useful and novel inventions.
Welcome to Tech Intersect. I'm your host, Tanya Evans, and my life and work exist at the heart of law, business, and technology. Yeah, I've earned a few fancy titles and degrees over the years, but the bottom line is I'm a writer, speaker, teacher, and lifelong learner, and I'm really excited that you've joined me on this journey. So what is Tech Intersect? Well, it's authentic, empowering conversations with really interesting guests who demystify complex topics to prepare you for the future, because your future is now. And it exists where law, business, and tech intersect. Get ready to listen, learn, and leverage. Let's get started. Hey everybody, welcome to another episode of the Tech Intersect Podcast, where we bring you the intersection of law, business, and technology. And I'm your host, Professor Tanya Evans, and today we have a returning guest, a friend of the show, someone who brings an incredible depth of knowledge to the table when it comes to navigating the legal landscape of Web3. JoAnn Holmes, founder of Holmes Law, is a seasoned attorney specializing in intellectual property, digital assets, and technology law. And last time Jo was with us, we explored the fundamentals of IP law in the context of Web3. And the response was phenomenal. It continues to be one of the most listened to and viewed podcasts in recent history. So that's super cool. And today we are going to dive even deeper into the legal pitfalls really can trip up Web3 startups. And specifically, we're discussing the top 5 mistakes that Web3 entrepreneurs make that can expose them to significant legal liabilities. So if you are a founder, an investor, or just curious about the legal intricacies of this rapidly evolving space, this episode is a must listen. We will talk about all of that and more in a moment. But first, JoAnn, welcome back to Tech Intersect.
It is always an honor and a pleasure to be with you, Professor Evans. Thank you for having me back. And I'm excited about this topic because you and I are very pragmatic. And so I'm looking forward to sharing the real world legal issues that entrepreneurs and founders in the Web3 space need to know to be successful.
We read the headlines every day. We see all of the projects, big and small, that come under regulatory scrutiny or some type of legal liability. And there's so many people who are operating in the space that they don't know, or underestimate the likelihood of some type of legal or compliance issue coming to their doorstep, or overstate the distance between this new concept, these novel concepts of doing business in Web3 and what the existing laws might be. And finally, and I know we're going to get into it, the fact that we have this ever evolving regulatory landscape at a state and federal level and globally. We're talking about global technology. So I'm hoping we'll help a lot of people, even if we're not answering all of the questions, because it depends. This is not legal or financial advice. We're here for edutainment purposes. I really want to see so many great companies succeed, and a lot of people will trip the legal wire unintentionally by moving forward and kind of failing forward. So we can talk about kind of the consequences of doing that without some type of checking in with the legal and regulatory issues as they're moving forward. So anyway, when I think about the mistakes, let me just list them all, and we kind of take each in turn and just hit the high notes of each. This could be like a 10-part series for sure. So let's see. So I was thinking about ignoring IP or intellectual property protections is a big issue, misunderstanding regulatory compliance, inadequate contractual agreements, poor data privacy practices, and finally, failing to properly structure offerings. Now there's so many different tokens, so many different projects. In the time that we have to speak, we could never fully take a deep dive. But there are some top of mind issues that innovators and the builders in this space should at least think about and get legal clarification on. So let's start at the beginning. We're both IP lawyers. I think you, as well as I, entered this space at the intersection of intellectual property and new technologies. And this was like the new shiny bauble. So talk about the consequences of failing to protect intellectual property early in a project's cycles and what steps they might take to avoid that and be more proactive with their IP.
I will say from the most baseline perspective, you and I both respect and appreciate that entrepreneurs need to do a balancing act between finding that product market fit where they have confidence that they're going to generate revenue, especially if they're not funded, as well as being aware and being proactive of some of the legal issues and steps that need to be taken early on so that that investment in building up that product market fit is going to pay off for you over the long term. Certainly, intellectual property is a piece of that. And so if we start from just a baseline, what are we saying when we mention intellectual property? So we've got trademarks, which are brands, logos, and slogans. We've got copyrights, which are the way that we protect original creative works. We've got trade secrets, which are competitive business advantages that you maintain as an IP asset by keeping them secret. And you've got patents, which, to simplify it, is the way that we protect useful and novel inventions. So if we're thinking through that, effectively every company is going to have a trademark because you've got brand names that identify the product or service that you offer. That's no different in blockchain technology. You want to think about how are you going to identify your products and services as separate and distinct from those of others. And this is really an issue in Web3 because sometimes the names, for example, of tokens can be very similar to tokens that already exist. Sometimes you can, let's move to copyright. Sometimes you have a design or an illustration and you might consider it a logo that's associated with your project. Well, that illustration could be protected under trademark as a logo, as I just mentioned. But if you have a use for that as artwork, it could also be protectable under copyright. So it's very possible that lots of Web3 startups, or for that matter, established Web3 companies, might have different types of intellectual property. And especially when we're thinking through the trade secret piece, being careful that you have contracts in place. If you have come up with something that's an innovation that makes your business stand out from those of your competitors, you want to make sure that you have confidentiality agreements in place, possibly non-disclosure agreements in place, and terms with your employees where you're protecting that intellectual property and affirming that it's owned by your business.
I think such a great coverage of the intellectual property landscape. And so often people forget to talk about trade secret as an alternative to patent protection, for example, right? And it makes me think of the best example of how you have intellectual property issues around one single platform. Let's just take blockchain. Satoshi, whoever he, she, or they are, did not go forward because it was launched from the beginning for the people, for the people's money, not to have any particular ownership, but that it was obviously a novel and useful invention when you think about this new way to combine peer-to-peer technology, the internet, consensus protocols, right? And also you have the title, both for the protocol, initial cap Bitcoin, and the native currency, Bitcoin, little b. And so we have trademark protection there. There's always this discussion about the patentability, but also the copyrightability of software code. But in order to file for federal protection for copyright, you have to put like a bit of the code in the beginning and the end. Maybe you don't want to disclose that, and certainly not for purposes of patentability, right? Because it's kind of the quid pro quo. You let us know and disclose how one with knowledge of the art can replicate that, and then you get exclusive rights to exclude others for a period of time. Maybe you don't want any of that, but having that conversation so that you can make a prudent and informed decision about what and under what circumstances. And then, final point about trade secret, that could be a really great way to protect, but it has its own process as well. So those are many, many things for business owners and innovators to think about from the beginning and on an ongoing basis. And so I really appreciate that. It's not every new business that has to worry about it, but every business on an ongoing basis.
Any Web3 company is an IP company, fundamentally. Right. And even if you don't think that you want to raise now, when you start to have conversations with investors, they're going to look at what are the assets of this business and how have you protected them. If you're thinking down the line about an exit, again, there's going to be an analysis and a diligence process around what are your IP assets. So for you to be in the best position for valuation, for fundraising, and for confidence that the assets that you have invested in building are protectable, you need to understand what IP you own and how to protect it. And frankly, once you do that, you need to understand how to maintain your rights in it as well. I hope that gives people a baseline around some of the IP issues to consider.
Excellent, excellent. All right, moving on to number 2, misunderstanding regulatory compliance. So this is like this huge umbrella. I was trying to figure out how to distill this into kind of bite-sized content that we could easily present. So let me get at it this way. We know that the regulatory environment around Web3, and that's a huge umbrella as well, is still emerging, still developing. It varies jurisdictionally. Can we, now we'll work together on this, kind of pinpoint some of the common regulatory issues as a matter of oversight that Web3 startups make, or how do they miss this when it's not factored in the beginning as they are building their tech stack, right? Or maybe their white paper and their raise. What are the regulatory issues that they may be missing that can easily lead to legal liability? So let's kind of get those back on their radar.
For someone who's sophisticated in the Web3 community in the United States, and especially if they have a token component, and we know there are different types of tokens. So you might think, for example, of cryptocurrencies as a type of token, but at the same time, as we're recording this, very recently, the SEC has taken a more aggressive position with respect to non-fungible tokens. And so when there's a token element, there's a question as to whether from a federal level, there's going to be a risk exposure from the Securities Exchange Commission, or the SEC, as well as the Commodity Futures Trading Commission, the CFTC. What's challenging about that in many regards is here in the United States, those regulatory bodies are not aligned as to who has jurisdiction or necessarily how tokens are classified, effectively, whether they're securities or commodities. And just to keep things interesting, securities are commodities. And so
that's the gag.
Absolutely. And a layperson can be forgiven for not, being able to navigate that when the regulatory bodies themselves are not clear around who has jurisdiction. If we step back to even a more 30,000 foot level, Web3 and blockchain technologies are global. So we have international law. One of the things that is helpful to some extent, looking at the landscape outside the US, is in many countries, their regulatory bodies are more streamlined than what we have in the US. And so whereas we have the SEC and the CFTC, in other countries, that regulatory oversight responsibility might be combined within one agency. Mm-hmm. So we've got international, we've got federal. And then when we're talking about assets, that can be treated as currencies, there are a myriad of blue sky laws where individual different states might claim further jurisdiction and authority from a regulatory perspective. So it's quite complex. And if you are starting a project, particularly where there is a token component, including NFTs, it is really wise to have a conversation with an attorney because there's two prongs of risk. One prong of risk is from any number of those regulatory oversight bodies that I just referenced. And another one is litigation, particularly here in the United States. The unfortunate reality is, to speak broadly, anybody can sue anyone for anything.
Very litigious.
And if you're plaintiff's counsel, within reason, it makes sense for you to sue everyone who might be liable and force them to prove that they should not be a defendant in that litigation. And so a lot of times startups will think, oh, I'm not the big fish that the regulatory agency would want to go after. But you might have participants, employees, investors, or others who are adjacent to your work, your product, your service, who, if they are disgruntled, might go to a plaintiff's attorney, and then you're dealing with litigation. Sometimes that litigation arises because your organization or one like it have caught the attention of one of those regulatory bodies. And where that ambiguity exists, there's opportunity, unfortunately, for litigation risk.
That's really, really helpful. And I see it a lot where something is not on the regulatory radar until it is, and then it's a class of things. You can see a number of issues. And so my initial response, and what you kind of alluded to, is the recent Securities and Exchange Wells notice that the CEO of OpenSea says that the company received, evidently, it was probably like a few weeks ago. And I will drop a link to an article that I wrote for Forbes that assesses that entire landscape. So we won't do that in the time that you and I have together, but I commend everybody to read that because it really starts to unpack. But the reason I mention it for us is this a signal to platforms like this, either the garden variety exchange for non-fungible tokens or NFT communities, where you might have tokenized access to opportunities, things that we wouldn't associate with securities, but given the SEC's very broad definition and going against one of the, in my humble opinion, and I don't know what's going on behind the scenes, but in terms of like a good faith platform that is there for exchange purposes, that is a signal to me. And time will tell whether this means that non-fungible token projects are now under greater scrutiny. And then it'll be something else. Will it be DAOs or this, that, and the other? It seems to be that the agencies, SEC in particular, will focus on a certain group of projects within the space to make movement there before moving on to something else. And time will tell. But any final thoughts about that?
I would say that we're in a particularly interesting time because of recent Supreme Court precedent in the Chevron decision, which is going to, I think, embolden more litigation with not just the SEC, but broadly regulatory agencies and challenging their rulemaking ability and the deference that was previously granted to these agencies. And so in the past, there's been established understandings around that deference to regulatory agencies like the SEC. We don't know how courts are going to align that deference with the recent Supreme Court Chevron ruling. I think it all the more creates a reason why it's necessary to be current and flexible as the legal landscape evolves.
Have you ever found yourself puzzled, wondering if cryptocurrency is just a fleeting trend, a scam, or perhaps the future? Hi, I'm Dr. Tanya Evans, and I'm here to introduce you to my new book, Digital Money Demystified, Your Ultimate Guide to Deciphering the Crypto Maze. As a legal policy and crypto education expert, I've crafted this book to cut through the chaos, debunk the myths, and tackle the FUD. That's fear, uncertainty, and doubt. From captivating headlines to meticulously sourced data, I guide you through the promises and the pitfalls of digital assets. With 12 chapters and 10 myths dispelled, Digital Money Demystified is designed for investors, business owners, and professionals eager to navigate the digital economy. It's more than just a book. It's a tool for economic empowerment that directs you safely and confidently from cash to crypto. Say goodbye to bewilderment and hello to enlightenment. Transform from crypto curious to confident. Sidestep those scammers and embrace the future of work, wealth, and creativity. Grab your copy of Digital Money Demystified today at the book's companion website, digitalmoneydemystified.com, or wherever books are sold. This is the right book, the right voice at the right time. Don't miss out on the digital revolution. Stop by digitalmoneydemystified.com now. Third topic would be around contractual agreements. So you and I both know that contracts are really crucial in any business, and there are myriad contracts that projects and innovators can enter into, but especially in the DeFi and Web3 world. Can you talk about some of the agreements that you come across that innovators in this space should be aware of, the things maybe that startups often overlook, and the potential risks associated with not having the right contracts in place or at the right time?
If we start from the baseline, as was famously said some time ago, corporations are people.
Right.
And not just corporations, LLCs and other entities are treated as separate and distinct from shareholders, members, investors. And that is really for us to be able to have a marketplace where people can feel confident being an officer, a director, an investor in an organization without putting their personal assets at stake. So if we start from the baseline type of contract, it relates to making sure that you are making a decision about the right kind of entity to establish for the objectives of what your business, product, or service will be. So let's say you're set up as a corporation. There is an agreement in the form of articles of incorporation and bylaws. Mm-hmm. Your business is agreeing to abide by those terms. And it is important to abide by those terms so that someone who takes grievance with the business can't pierce through that corporation and get to the officers, directors, or even in recent precedent, there have been examples of trying to go after the investors. And so if you start from the baseline, make sure that you have those agreements. If it's an LLC, an operating agreement that sets in place how you will govern the business in accordance with law and in its contractual relationships. Then there are any number of agreements, whether in DeFi or otherwise. There are employment agreements that lay out things like what vesting schedules will look like or what share issuance will look like. And again, as we mentioned before, reinforcing intellectual property. Any business is likely to have a number of vendors and you need to offset risks. So let's say you're entering an agreement as a Web3 company. Two of the things I'm regularly focusing on is reinforcing your own intellectual property rights and then offsetting risks that others who you do business create for your business. That's called an indemnification or a hold harmless term. You will have any number of agreements with your investors. And those are very important because we're all in business to make money. If not, what you have is a hobby or a nonprofit.
Amen.
We want to make sure that those agreements are clear so that there's an understanding around how capital will be raised and distributed. So there are any number of agreements that come into place that just because we have a blockchain technology based or a Web3 industry business, we are not immune from that. One of the reasons why it's important to do that is because we are entering contracts sometimes without even realizing it. I'm sure if someone sees lots of small print and a signature block at the bottom, they recognize they're signing a contract. But things like the terms and conditions of your site, that's a contract. Emails exchanged between parties where someone's making an offer and someone's saying, great, I agree to those terms. Let's go. Those are also agreements. So you want to be aware of what creates an agreement. Ideally, it should be in writing. Ideally, you should do things like choose the governing law, which is important again because Web3 is global first. So you want to choose the law that is going to be friendly to your objectives. But if I were to break this down, the most important things to keep in consideration with contracts are making sure you're protecting your personal assets, those that you and your family have built up, that you're being clear about protecting the intellectual property your business is creating, you're offsetting risks, and you're clear about capital formation and distribution.
How do you think, if at all, about the role that a white paper plays into all of this? This has come up quite a bit. It used to get, I don't know if there were so many questions, but I had questions when people would show me their kind of like technical white paper versus kind of the generalist approach. A lot of claims. Some claims, particularly in technical white papers, that if they were up for over a year would preclude our ability to actually move forward to secure a patent because it became public information, the step-by-step process where people were trying to be transparent. But if it was longer than a year, then it prevented them due to the rules of even moving forward to the extent that they wanted to secure a patent. That's like probably a story for another day. But as you were describing the different levels of relationships contractually, and you and I know offer acceptance consideration can take many forms. We would like it to preferably be in writing. Not all writings people ordinarily would think about being a contract. And then, of course, oral contracts and the respective law. So any thoughts about how people might be careful, or at least the issues that they should have top of mind about their white paper that they're sharing as well, and some of the promises made there?
General guidance to clients is when you are making a decision, understand how this aligns to your objectives. If you are trying to be transparent, engender trust, give a landscape so that people understand the reasons for entering a community and why to support that community. That's effectively marketing, right? But marketing also has rules. And so understanding, if we go back to some of the governing regulatory agencies, the Federal Trade Commission has jurisdiction on many different types of marketing claims and disclosures. And so you want to be careful about not running afoul of that. To your excellent point, there could be patentable information. There could be trade secrets that you are disclosing within the context of a white paper. Another thing that we want to be careful about, whether it's in a white paper or any other such public disclosure, again, thinking back to the history in the United States and some of the challenges that have been encountered with the Securities and Exchange Commission, if you are speaking to the financial acumen, the past financial success of the project, of its founders, if you are making representations that a reasonable person would think lean into the returns that can be made on an investment. If you are suggesting that someone buys in and then the result is going to be something you're going to go and build that doesn't already exist, especially if we're talking about gaming or metaverses or things of that ilk, it starts to look like an investment contract, or it becomes subject potentially to regulatory disclosure rules. And so there's a lot that can have good intention.
Right.
And I know that one of the fundamental principles of blockchain technology is that we want to use trustless relationships. And so I understand the objectives, but at the same time, as you mentioned earlier, Tanya, we are innovating within the space of everything that existed before. And so when we are doing that, we didn't just fall out of a coconut tree.
I saw what you did right there. I wasn't going to laugh, but I heard what you did right there. Keep going.
And so if we are going to do that contextually, we can have every good intent and we can be successful, but we need to do that as good stewards of our communities, of our work, and of those who stand behind us to produce and distribute that good work. We need to contextualize it within the laws. And I think in the Web3 community, there's been some pushback, but some of those laws are in place very much so to protect people who don't have the same knowledge as the people who are building. And if we take a larger perspective on wanting to protect our community, it requires some balance. And part of that balance is being aware of the law and regulations that have impact on what we put out publicly and how that can be perceived and received, where there's an imbalance of information.
Absolutely. The mistake or things that we want builders in this space to think about is failing to properly structure things from the beginning, which can really be quite challenging. And it leads me to a related issue. Maybe we talk at a broader or higher level about this particular issue. It's just the decentralization dilemma. It came up a lot where a reasonable argument could be made that Ethereum, the network and the native coin when first launched was a security, an unregistered security. But over time, through decentralization, and there's a broad umbrella under which that exists as well, because there are many different steps to something that is fully centralized to something that is quote unquote fully decentralized without a proper definition of that. And also just a recognition of the fact that token projects can change in their form. Ethereum is a great example. From centralized to decentralized, you could technically have something that was decentralized to centralized. It is something that is far more dynamic than securities laws could appreciate in the 30s. And so what does that mean for token projects now, not being sure of the regulatory environment, or what decentralization means to the SEC, for example, and what steps you might think about in the beginning to at least make a good faith effort to start in a way that would minimize the likelihood of legal liability or regulatory concerns?
So as I was listening to you, a few things came to mind. If we go back to fundamentals, in a legacy business, you're going to have founders very early on in exchange for shares assign their IP rights to the company. And when I say company, I mean in its form, be it a corporation, an LLC, or otherwise. And so one of the issues that could arise when you have decentralization is who created what intellectual property? If we wrote code together, are we co-authors? If we design something that is useful and novel, are we co-inventors on something that is subject to patentability? Did those individuals retain those rights? Do you even know who those individuals were, right? You have certain disclosure requirements. And so if you're going to disclose, you need to know who the people are
Right.
who are involved in inventing. And when you don't know that, you open yourself to potential risk and liability down the line, which happens to arise when you start to commercialize and you start to have profitability. There's no money on the table. There's not much to fight about.
Agree.
So I think about some of the proposals that have been made. And one that I think has some merit and is worth further exploring is this concept of a regulatory sandbox. And that is because it is not possible for something to be cohesive, productive, find that product market fit, be commercialized, for contracts to be entered, for relationships to be built, for reputation and goodwill to grow without having a steward, right? There needs to be some centralized nucleus that is going to steward a concept through to completion and evolution and iteration. And so the challenge is to use, some of the examples that you shared with Bitcoin. By the time it came to the fore and regulators started to pay attention, it was widely acknowledged that certainly at this point to be sufficiently decentralized. That's why there's no argument about whether it's a security or a commodity. But if we talk about Ethereum or basically any other coin, you have a group of people who come together and have an idea about something that will have value and that they are working behind and coding behind and marketing and stewarding that community. That is centralization. But it is completely possible to get to decentralization. And so to give the legal and risk cover that comes with a potential regulatory sandbox, where within parameters that are meeting that balance between consumer and investor protection and innovation flourishing and job creation here in the United States, we have a case for that regulatory sandbox. Because we can't have something born out of the mind and come into its full existence without someone stewarding that. And for all of the reasons we've spoken about and more that we may not know, where there is a lack of legal and regulatory clarity, that sandbox makes a lot of sense for balancing the various interests at play.
I hope that regulators, legislators, policymakers, and interest holders will really take a second look at this idea of the sandbox, because other countries are certainly moving forward to create this regulatory space, either to proactively decide not to enforce existing rules while you have this private-public partnership to figure out what the parameters should be with a nascent technology, or to create for a limited time certain rules and regulations that will continue to be developed over time so that people will innovate here in the United States without this constant cloud over their heads that is pushing so much of this work at kind of the large cap and the individual capacity that can, I mean, they have a customer service issue here in the United States. There are other places and spaces, UAE, Singapore, even Canada and other places. That doesn't mean the regulatory environment is easy or simple. But to your point earlier, for other countries that don't have the kind of the regulatory alphabet soup and morass that we have in the United States, they can be more nimble. They could be more forward thinking. And so there's a customer service issue about maintaining that here. And also, again, to kind of finish up, focusing on the builder and the innovator. So often we're talking about investors who are going to move forward with this quote unquote new gold rush, but someone may never invest, but may invest in a company that will build and provide kind of the axes and the eggs and the shovels and the tin cans of this new gold rush. And they should be able to do so on a good faith basis with some level of clarity and security. So that being said, I thank you so much for your invaluable insights today. I know we just, kind of scratched the surface to be sure, but I think that this conversation is going to help a lot of folks to put to the top of mind why the ability to measure twice to cut once is really where you want to be. And it is kind of like a fool's errand. I'm trying to remember how my Nana used to say it, but this idea of like the false economy, where you're saving money on the front end, but it costs you 10 times as much, and not just money. It could cost your liberty. It could cost your reputation. And so having a line item in your raise or your build, or if you're getting grants or investor money, that should always include something for lawyers and having these conversations. So final thoughts on just where a lawyer fits in as someone is starting a project or reassessing. Is it like the rule is like today and yesterday? That's the two best times? Or when is the best time to check in with a lawyer when they're building?
So I would circle back to come full circle to the beginning of our conversation and talk about being pragmatic and finding that balance between when you have some confidence that you've found that product market fit. So there's revenue that you anticipate generating to offset the cost of conducting a business, including the legal investment. Or when you've got investors and you're anticipating that you're going to be needing as a founder to sign documentation, make sure you're properly represented. It's rare in my career that I've seen agreements that are drafted only by one side and are fair and equitable to both sides. So that's another occasion. I would say my clients are oftentimes surprised that I work predominantly on a flat rate basis. And in Web3, almost everyone is a founder, or even for the more established companies, they're still figuring things out. So understand that there are attorneys who will work on a flat rate so that you can figure out, does this fit into your budget? And you can make that decision in advance as opposed to having an invoice on the back end that's maybe different than what you intended. I would also just, because again, we both pride ourselves on being really pragmatic and we care very much about this space being inclusive and opportunity so that the participants, the founders, the builders, the investors look like the global community that Web3 serves. I'd like to share a few pragmatic tips to run back over some of the things that we said are risks, right? So if I'm thinking about this from the perspective of being a business owner myself, understanding that every business, whether it's a startup or a multi-billion-dollar business, has a budget, and we're all looking for pragmatic tips on how we can do things cost effectively and efficiently. If we're looking at intellectual property, you can search, for example, here in the United States and in many other countries around the world, you can do a rudimentary trademark search for free. On the U.S. Trademark Office website here, there are international intellectual property organizations where you can run rudimentary trademark searches for free. Copyright applications to protect your artistic or creative work, less than $100 to get a copyright registration. Google searches are free. Social media searches are free. So you can go see who else is using similar brand names or artwork to yours, right? So those are some cost-effective ways to start getting awareness around the intellectual property piece. In terms of regulatory, not to mention the outstanding Tech Intersect podcast, There are a myriad of YouTube channels and podcasts where you can get free information. So while you're doing your chores or driving your car, you can get up to speed on some of these regulatory issues and think through, where are my potential risks? Where can I navigate around them? One simple thing is, if you don't need a token, if there are other ways that you can build and provide the value you want to provide to your community without involving a token, think about how to structure that way. That's one less risk, regulatory risk for you to consider. Same thing on regulatory. There are places like Clerky, for example, where you can go get a baseline start to setting up a corporation. And when you get to a situation where you're starting to find that revenue generation or you've got investors, then reach out to an attorney and someone who can negotiate and advocate on your behalf. With your contracts, I would generally suggest that you don't grab some other contract and use it. That's probably one where you want to speak to an attorney, but go in ready to make the most of that interaction with an attorney around the contract. For example, set up some deal terms, send some emails back and forth, and do a one-page Google document on what the key deal terms are, so that when you go to an attorney, you're paying for the things where that attorney can provide the greatest level of knowledge in drafting or negotiating for you, and you're not paying the lawyer to go back and forth on business terms. So there are a number of ways that you can use free available resources, low-cost resources, and then when you lean into counsel, you're doing it having done the work to take the greatest opportunity to have that counsel step in and be your advocate, understand your business objectives, and help deliver those goals for you.
That's outstanding. And this was all free 99. The next conversation with Jo, that's going to cost you. And we're going to send you there. She forgot the best resource, and it happens to be holmes@law.com. Talk about where folks can reach out to you and learn more about you and your work.
Well, I feel like every time I speak to you, I say this because every time I speak to you, I mean it. Continues to be an honor. I am so grateful for the work that you do in this space, educating, sharing of your extraordinary knowledge, and being a smart, pragmatic advocate for why this technology matters, why we should create these jobs in the United States, and giving us a roadmap for how that can be done. So thank you. I'm giving you your well-deserved Netherlands, Amsterdam level tulips and roses and all that you are worthy of. So thank you for that and for your friendship, Tanya. In terms of the way that people can contact me, as you said, my website is Holmes, like Sherlock, Holmes Act Law. So HOLMESATLAW.com. But the best way to connect with me so that I can follow your work and you can follow mine is on LinkedIn. So I look forward to communicating with whoever would like to reach out. And I commit, like you, to continue to be an advocate for this technology to grow and flourish in the United States, for it to be diverse, unapologetically inclusive, and to create wealth opportunities in Web3 and blockchain technology.
Excellent. Well, my friend, I'm so grateful to you for hopping on and having this conversation. I absolutely look forward to future opportunities, and I know we helped a lot of people, so thank you, my friend.
My pleasure.
Thank you so much for listening to the Tech Intersect Podcast. I hope you enjoyed this episode. If you love it, please tell the world. If not, go ahead and tell me. And in either case, drop a comment or ping me on social media at IPProfEvans with the hashtag Tech Intersect. And finally, a quick reminder on digital safety. There are a lot of scammers out there impersonating me and others, and I need your help. Now hear this, and remember, I will never slide into your DMs to say peace and blessings or hey, and I will never reach out to solicit your time or your money on social media, like ever. I'm not a trader. I am an educator and an attorney licensed in 4 states. Thank you very much. I'm here to inform, inspire, and empower. No cap, and definitely no Forex. So be careful, make good choices, and remember, I developed an entire free masterclass about the topic of digital safety in the crypto space. So check out secureyourcryptobag.com for more information. That's secureyourcryptobag.com. All right, that's all for this episode. Until next time, continue to shine. Hey there, Tech Intersect listeners. Have you ever encountered naysayers claiming crypto is too volatile, a total scam, or a hacker's paradise? Well, it's time to dispel these persistent myths and reveal the truth. It's exactly why I wrote Digital Money Demystified, available now wherever books are sold. And this book is your golden ticket from being crypto curious to radiating crypto confidence. Navigate the crypto world with clarity and conquer the chaos. Get your copy today to learn about my journey, separate fact from fiction, and maybe even embark on a transformative journey yourself. Don't stop there. Enhance your learning experience exponentially. Join the DMD Insiders Membership Club. It's a gateway to premier coaching, engaging community, and unparalleled content that complements the insights in the book. Together, we'll unlock the potential of digital money and stride confidently into the future. Visit digitalmoneydemystified.com, grab your guide to the crypto universe, and become an esteemed member of our Insiders Club. Let's decode the digital dollar and invest in your crypto savvy future right now.